welcome to today, March 4th, 2025's AIA Canada Tariffs 2025 webinar. My name is Joel Smith. I'm a labor and employment lawyer. I'm a partner at Williams HR Law based in Markham, Ontario. And I act in all aspects of labor and employment law, whether that's wrongful dismissal matters, privacy issues, human rights, harassment, you name it. And so I'm here today to talk about the employment law implications for employers in the auto care industry. I'm recording this again on March 4th of 2025, the day that the new U.S. tariffs have been imposed on Canada, and Canada has announced retaliatory tariffs, like I'll talk about more in just a moment. And so I act for a number of different employers in the automotive industry and in the auto care industry specifically. And so I want to discuss, specifically for employers in your industry, what do you need to know? What are some of the liabilities? What are some of the options that you have to prepare and plan and confront these tariffs that may be impacting your business going forward? And so I'd like to just say thank you to AIA Canada for inviting me to provide this webinar to you, and thank you to all of you who are spending the time watching this recording to really help understand what you need to do. So without further ado, I'd like to jump right in and start off by just talking a little bit about the current status of the tariffs. As I'm sure those of you who are watching already know, again, the U.S. has imposed, as of today, March 4th, 2025, 25% tariffs on virtually all Canadian goods being imported by the U.S. Canada has retaliated with a significant portion of tariffs of their own, and Prime Minister Trudeau has announced that further tariffs are likely to come if the U.S. tariffs remain in effect going forward. The U.S. has itself responded to that by indicating that they're going to retaliate to Canadians, the Canadian government's retaliatory tariffs themselves. And so there may be further tariffs coming from the U.S. government as well. And that's in addition to potential additional industry-specific tariffs. The U.S. government has indicated that they may be implementing and imposing further tariffs specifically on aluminum, steel, and the automotive industry, as well as other tariffs more broadly worldwide, which may stack on top of the tariffs they've already imposed against Canadian goods and services. And so a lot happening here. As it stands right now, the Canadian government has indicated that along with those retaliatory tariffs, which it may increase in the coming weeks, it's also looking at determining how it can provide further support to Canadians as well, both through the employment insurance scheme. They've indicated that they're planning to create more flexibility in that scheme to provide support to workers who may lose their jobs temporarily or permanently as a result of these tariffs and the business impacts of them, as well as indicated that they're looking to provide support to businesses directly who may be impacted by the tariffs as well. And so, of course, that may well impact all of you watching here today as employers and what you might need to do to respond to these tariffs. But, the support that may be provided by the government may not provide all of the support that you need. You may need to look at some human resources decisions, some tough decisions in response to these tariffs, and that's primarily what I'm here to speak to you about today. Is to understand what are your options, what are your liabilities, what can you do to confront these tariffs, and from a workforce perspective, if you are going to have a significant downturn in business and sales, which is what economists are suggesting is likely to occur if these tariffs do stay in effect, you're going to need to look at cutting some costs in some cases. And so hopefully we can get these tariffs resolved quickly, and this won't be an issue going forward. And if that isn't the case, hopefully the support provided by the government will allow you to avoid a lot of these tough decisions. But to the extent that you may need to look at workforce cost reductions, you need to understand what your options are and what's legal and what you can do. And so what I'd like to speak to you about here really is two primary things: temporary layoffs and terminations of employment. And so if you might need to look at temporary layoffs, what are the rules around that? What are your options there? And if you need to look at permanent terminations of employment, what are the rules around that? What are your options there? What are the potential liabilities that you might face? Because, of course, if you're looking at layoffs and terminations, you're looking at reducing costs on a go-forward basis, but you need to understand what the costs are of actually implementing those decisions themselves, because in some cases that will cost significantly more than a lot of employers might expect. And so fundamentally, what I want to start off with here is just to let you all know, in understanding your options, the sooner you understand them, the sooner you look at what you have in place, what the costs might be, what your opportunities might be here, the more opportunities you have, the more options you're going to have, and therefore, the more of the liability that you'll be able to mitigate as a business and as an employer. And so with that, I'm going to bring us now to layoffs. Let's talk about temporary layoffs. First of all, when I'm talking about temporary layoffs, really what I'm talking about are temporary workforce reductions where an employee is placed on layoff. Generally, they may be eligible for employment insurance, but it depends on their eligibility there. But a temporary layoff where the employer is not continuing to pay that employee for a limited period of time in order to respond to a short-term reduction in sales or income or whatever the case may be. The idea of a temporary layoff typically would be either there's uncertainty and there's a hope that you'd be able to bring the employee back, or there's a certainty that you'll be able to bring the employee back in a relatively short period of time. And so with the uncertainty that we see with the tariffs right now, with the Trump administration's frequent changes, I'll say, in their approach to these tariffs and many other decisions that they've been implementing, it's very possible that these tariffs might be resolved in relatively short order. And so, temporary layoffs may be a really good tool for you to be able to retain that great talent that you've trained and worked on, and be able to bring them back and protect their jobs, while at the same time, avoiding some of those costs that you may face from a termination of employment perspective that we'll talk about more in just a couple of minutes. And so if you're going to be looking at temporary layoffs, some of the things you need to understand. First of all, there are specific rules set out in the employment standards legislation across the country. So whatever province you're operating in the auto care sector, you're generally going to be governed by the provincial employment standards legislation. It's usually called the Employment Standards Act or the Employment Standards Code of whatever the province is. And so there are certain rules that are set out there. Generally, there's going to be a maximum duration of a temporary layoff. And if someone is laid off for longer than that maximum duration, then it'll be considered to be a termination of employment, and the employee will be entitled to whatever their termination entitlements are. Again, I'll talk about that more momentarily. So first of all, when we're talking about durations, I'm going to talk about just a couple of provinces to provide kind of good examples. In Ontario, a temporary layoff under the Employment Standards Act of Ontario can be up to 13 weeks within any 20-week period, unless certain compensation or benefits are provided to the employee. So the most common example there would be if the employee's health benefits, health and dental benefits are continued, and those are paid for at least in part by the employer, as they were before the layoff. If that happens, then the employee's layoff can be up to 35 weeks within a 52-week period. So that's in Ontario. In BC, the rule is quite similar. It's 13 weeks within a 20-week period. That 35-week period does not apply in BC. It's just that the base level 13 weeks within 20. And then in Alberta, it's a similar time period, but calculated differently. It's 90 days within any 120-day period. That would be the maximum duration of a layoff. Now, other provinces have some similar rules. Others vary more. What you need to bear in mind is that there are a variety of specific rules within each province when it comes to temporary layoffs, not only about the duration of a layoff, but also about things like what type of notice is required to implement a temporary layoff, what type of notice is required to recall somebody from a temporary layoff. What are some of the special rules that might apply? For example, again, in Ontario, there can be exceptions if an employer and a union for unionized employees have a different agreement in terms of how long a layoff can last for. So these are all different types of potential agreements that can occur, different types of special rules. You need to look at the specific rules for your province to understand, what you're dealing with. And I strongly encourage you, if this is something that you might have to consider, temporary layoffs, get legal advice from an employment lawyer who understands the law in your province. I'll note I provide advice and services to organizations across the country, with the one exception of services being provided in Quebec because of the different legal system there. But whether it's with me, whether it's with whatever lawyer you've dealt with before, make sure you're getting advice so you understand what those rules are, because they do get to be complicated. Now, if you're unionized, in addition to there potentially being some different rules in the employment standards legislation, you need to also consider your collective agreement with the union. That may have some other different rules that pertain to employee layoffs. Now, a really important thing that you need to bear in mind, and this is a general rule nationwide, employers are not permitted to temporarily lay off employees, even if you follow the rules in the employment standards legislation that I've been talking about. You're not allowed to do it if it's a non-unionized employee unless the employee has agreed to the right to lay off. And so most commonly that agreement would be within the employee's written employment agreement. So most commonly you would have, if you have this right, a clause somewhere in the employment contract or offer letter that says that the employer does have the right to temporarily lay the employee off. Often they'll say something like, the employer may temporarily lay you off in accordance with the applicable employment standards legislation. The specific language varies, of course, but the idea is that the right needs to be set out and agreed to with the employee. If it's not set out in the employment agreement, there is sometimes the opportunity as well to agree with an employee specifically for a layoff at one specific period of time. So, in this period, if you don't have the right to lay somebody off, you might be able to agree directly with the employee to say, in an effort to try to protect your job, we're going to agree that you'll be laid off for X period of time in accordance with the legislation. And so employees may or may not agree to that, depending on whether they think they'll be recalled, their interest in getting a package, what have you. But that's another potential opportunity as well. Big picture, though, again, being you need to have that right set out somehow with the employee. They have to have agreed to you having the right to lay off. You can't just comply with the employment standards legislation and expect that that's all that you need to do. Now, again, as I mentioned before, if a temporary layoff expires, if they lay somebody off for that full duration permitted under the legislation and you're not able to recall them at that point, they'll be considered to have been have their employment terminated without cause, and you'll be looking at termination obligations and payouts that I'll talk about in just a second. Similarly, if you temporarily lay somebody off and you don't have the right in the employment contract or otherwise with that employee that you're able to do that, then generally the law would be that you've dismissed them, even though your intention was just to temporarily lay them off. And again, you'd be looking at those termination obligations, those notice or pay in lieu of notice obligations that otherwise would apply only at the end of the temporary layoff period if you can't recall. So to spend a bit of time about terminations of employment, again, this is if you're talking about a permanent reduction, either because you can't recall from a temporary layoff or because you just know right from the making of the decision that you're not going to be able to call them back, or if you don't have the right to temporarily lay off and the employee doesn't agree to it, then you're looking at generally a termination without cause. If your employees are unionized, the collective agreement's going to govern, whether there's any other entitlements beyond the minimums under the employment standards legislation that I'll talk about. If they're not unionized, then there's broader obligations that you would have as an employer and potentially significant payments owed to those employees. So generally across the country, employers are required to provide notice or pay in lieu of notice of termination without cause, and workforce reduction related dismissals generally would be considered to be a termination without cause. And so in those circumstances, the default is that the employment standards legislation will provide a certain amount of notice or pay in lieu of notice that the employer has to provide to the employee who's being dismissed. These amounts do vary somewhat across the country. Most provinces are approximately 1 week per year of service up to 8 weeks. So after 8 years of service being 8 weeks of notice or pay in lieu of notice. And that's the usual rules. Again, they do differ somewhat. Some provinces are quite a bit different than that. Many of them are either exactly that or very close to that. But that's the most common. Again, make sure that you know what you're dealing with in your province. In addition to that notice obligation in Ontario, which is one of those provinces that requires approximately 1 week per year up to 8 weeks maximum, larger employers with at least $2.5 million in annual payroll owe longer service employees with at least 5 years of service an additional statutory severance pay, and that's about another week per year up to 26 weeks. So unlike in other provinces where typically it's 8 or in some cases 10 weeks as a maximum of notice, Ontario has 8 weeks maximum notice plus potentially another 6 months, 26 weeks for those longer service employees, employed by larger employers. And so those are the bare minimums under the employment standards legislation. And those aren't small numbers by any means. But those are small relative to the other default rule that applies to non-unionized employees. And that other default rule is something called common law reasonable notice. And so for those who may not be aware, common law is judge-made law, it's court-made law. And so the courts in our country, across the country, have implemented this parallel entitlement for employees who are dismissed without cause. That generally the idea is intended to give them notice for however long the court deems that they should need to get another comparable job. what the courts really do is they look at certain factors like age, length of service, the position and the position within the hierarchy in the employer, compensation, what have you, to look at other similarly situated employees and what courts have awarded in those cases. But in general, this common law obligation is going to be quite a bit larger than the obligations that you would owe under the minimums under the employment standards legislation. So whereas in employment standards legislation, in many cases, it caps out at about 8 weeks. Usually 8 weeks or so, 2 months or so is actually on the lower end for really short service people from a common law notice obligation perspective. And it can go all the way up as high as 2 years, and in extreme cases, even higher than 2 years of notice or pay in lieu of notice. So that common law obligation is significant. Now, you should bear in mind, really importantly, if you are non-unionized, that common law obligation only applies if you haven't entered into an employment agreement containing an enforceable termination clause with the employee in question. So if you have an employment contract that has a termination provision, a termination clause that's intended to limit the employee's entitlements at termination, if you haven't entered into that, that can actually limit their entitlements to as little as the minimums under the employment standards legislation. Again, that's the up to 8 weeks that I've been talking about in most provinces. So it can be as little as that if the contract has the right language. That's a really important thing for you to bear in mind. If you're not sure if you have an employment contract with your employees that does have a clause like that, review it and get advice about that. It's really important that you do understand what you're dealing with, so that you understand, again, what those costs could be if you are facing a termination of employment. Now, when you're, again, considering these terminations of employment, I talked about the general rules under the employment standards legislation. The other thing to bear in mind are the mass termination obligations that many provinces have. So I'll give you Ontario and BC as an example. If at least 50 employees are dismissed within a certain period of time, it's 4 weeks in Ontario, 2 months in BC, and there's similar rules in other provinces, then employees have a certain higher minimum entitlement to notice or pay in lieu under the legislation. So in both Ontario and BC, depending on how many employees are dismissed in that short period of time, it'll be either 8, 12, or 16 weeks of notice for everyone. And again, that's before accounting for the potential common law notice entitlements that generally would be greater if those haven't been contracted out of with the termination clause. So you want to bear all of those things in mind, understand, what are you looking at, how many people might you have to let go, and really assess what are the costs of dismissing them, not only under the employment standards legislation, but also under common law or the contractual entitlements that these employees may have. Now, when we're talking about these employment contracts, again, you want to consider, do you have temporary layoff clauses? Do you have termination clauses? But simply having a termination clause that says, kind of in plain language, what the employee is entitled to is often not enough. In general, our courts in Canada don't like to enforce these termination clauses, to put it frankly. And so generally they look for pretty technical reasons why they can choose not to enforce those clauses. They'll find technical reasons to say these clauses are not legally enforceable. And so the employees are still entitled to the common law notice that I was talking about, despite that the parties agreed to this termination clause in the employment contract. And so in provinces across the country, the courts are finding new and creative reasons why they can say these termination clauses are not enforceable. I won't get into the specific legal rationale that they use in the different provinces, except to say, in many provinces, the law is changing very frequently. In Ontario, again, is an important example. Just in 2024, there was a big decision early in the year called Dufo, where a judge of the Ontario Superior Court of Justice rendered a decision that suddenly amounted in a lot of termination clauses that were in effect in the province and before the day that decision came out were enforceable, suddenly no longer being considered enforceable because of this case. So, there were many thousands of employment agreements that were all of a sudden, no longer worthwhile when it comes to their termination clauses the day that decision came out. The employer in that case did appeal the decision, but just a few weeks ago, the Court of Appeal decided not to overturn the decision. So that decision is still good law, and it has resulted in a lot of contracts not having enforceable termination clauses any longer. And so, if you are an employer that does have contracts that do have termination clauses, but you haven't had them reviewed in the last few months, especially if you're in Ontario, but if you're elsewhere as well, strongly recommend, again, you get advice, have those contracts reviewed before you're considering, any terminations, because you need to understand, for example, an employee who's been there for 5 years, are you talking about 5 weeks of notice under the employment standards legislation in many provinces? Or are you talking about potentially 6, 7, or 8 months of notice or pay? Because those are very different amounts. And if you're doing the math to determine, how can you keep the lights on, you want to know what you're actually looking at paying out. Now, in addition to checking whether you have these, and if you do have them, whether those clauses are enforceable, the other thing you want to consider as an employer is, if you don't have them, what can you do? Do you have the opportunity potentially to enter into agreements with employees, maybe new employment contracts that have layoff and termination clauses, or just kind of direct agreements specifically giving you the right to lay off? There may be opportunities like that in different cases. Again, the earlier that you do this, the more likely it is that you may have options available. I want to be clear. Not in every case will you be able to enter into an employment agreement with a termination clause, if you're expecting to dismiss the employee right away. In many cases, in a situation like that, a court might not be willing to enforce that contract because of the circumstances and what you knew at the time of entering into the contract. But the sooner you look into this, while there are still a variety of options ahead of you, the more likely it is that you do have different options, which might include entering into new contracts with your employees. And so, again, just a call to action here. Look into this, take your steps as soon as possible, and get your advice as soon as possible, so you can determine, what your options are when there are more options available to you. So the last point that I want to cover quickly here before I wrap up are that there are a variety of other employment law related considerations relevant to the tariffs that the US has now imposed against our country. Some of the key ones that I want to just quickly put on your radar, more details and discussion for another day, but quickly put on your radar are that when it comes to political expression, there can be some significant legal obligations and liabilities that you can face as an employer. Political expression, this is something that we've been seeing more and more over the past few years. For example, during COVID, there was frequently discrimination against employees from China or Asia more broadly because of concerns about where COVID came from, and that resulted in discrimination, creating liability for employers, creating an uncomfortable working environment for those employees. We might see something similar now as we're seeing more and more nationalism, with Canadians being very upset with Donald Trump and the U.S. more broadly as a result of this. We're seeing this, for example, at sports games. Canadians are often booing the U.S. anthem. This is becoming a more and more prevalent belief and opinion, and this can result in American employees or employees who are sympathetic to the U.S.'s decision making here, or who may have family in the U.S. They may face, an uncomfortable working environment. They may face comments from their coworkers who are unhappy with, what America is doing and are linking those people to those decisions by the U.S. government. And so, in situations like that, there may well be human rights implications because, across the country, there's human rights legislation that governs in each province. Generally, there's some sort of protected ground under human rights legislation like citizenship or country of origin or place of origin, all of which would likely apply in the case of an American employee being treated differently because they are American. That can result in liability for you as an employer. You can be facing claims and damages that you might have to pay out. And so that's something to be on the lookout for. And on top of that, depending on the nature in which that type of discrimination or differential treatment of American employees might occur, it could also amount to harassment at work, which would then engage employers' obligations to investigate harassment under occupational health and safety legislation in your province, and potentially again result in damages and liability for you as an employer if that sort of thing does occur in your workplace. And so you want to look at your policies, whether you have policies that would apply in cases like this. Would be things like a harassment policy and anti-discrimination policy. It might be your code of conduct and some other policies you might have. Look at what you have and reinforce the expectations for your employees to ensure that you're taking a step to try to limit this type of conduct and limit your liability as an employer. And if you don't have those types of policies, if these are issues that you think might occur in your workplace or that you're already seeing, take a look. Consider implementing new policies to really make sure that your expectations for your employees are clear. So with that, that's my my whirlwind webinar for you here today on this significant day in Canadian history of new tariffs for the first time in a very long time being imposed by the U.S. Thank you again for spending the time watching this webinar and digesting some of this information. If you do have questions, please don't hesitate to reach out to me. There's a QR code on your screen there that you'll be able to take a look That'll bring you to our website, which is williamshrlaw.com. You can find my bio on there. You can find our telephone number. Please don't hesitate to reach out. Happy to provide answers to your questions and help you, manage through this difficult time as an employer. Thank you again, and thank you again to AIA Canada for having me.